And thanks very much, Michelle. Good afternoon and welcome to the Fundamentals series. My name is Patrick Shepard. I'm a lead instructor here at OGE, and I'm very pleased to be joined today by Mark Stewart from OGE's Compliance Division. Mark and I have worked together here at OGE for more than 10 years, and before that, Mark, you were an attorney in the Coast Guard. Is that correct?
That's correct.
Excellent, and I think you did some 450 stuff when you were in that role as well, so you're not new to this.
That's absolutely correct, Patrick. I did it as a collateral duty.
Fantastic. Well, welcome, Mark. I'm very pleased that you could join us, and we're going to turn it over to you in just a second, but before that, we have a few announcements. The first announcement is next week we're going to be in St. Louis for a regional symposium. So those of you who have signed up for the regional symposium in St. Louis, I look forward to seeing you there. Also next week on Thursday for our Advanced Practitioner series, we have Patrick Kelly from the Federal Bureau of Investigations. And he's going to be discussing compliance and ethics and how they work together in the FBI's organizational compliance program. So please do look for that. Registration is still open, or will open tomorrow rather. We also have registration open for a regional symposium in Research Triangle, North Carolina, and that's scheduled to take place on April 15th. So if that's in your area and you'd like to come in for some live in-person training, we will be in North Carolina on April 15th, so please look for that. And a reminder, as always, if you're looking for tools and products to put to use in your programs, you can find those on the IEG Max community in the store. And if you have products to share with your colleagues, please check out the store because you will be able to share those with the colleagues, and you can find the instructions for doing so on the Max page. So with that, should we get into the slide, Mark?
Yes, please.
Excellent, and it is all yours, sir.
Thank you, Patrick. And once again, my name is Mark Stewart, and I've been here for a while, but I actually had a career in the Coast Guard. And as for most military careers, you switch from duty station to duty station, and I actually had ethics as a collateral duty twice in my Coast Guard career. And in my second tour, which was pretty much close to the end for me, one day my boss came in and just dropped a bunch of 450s on my desk and said, "You're doing the 450 program this year." And I said, "Great, what's that?" I had dealt with ethics, but I really hadn't dealt with financial disclosure. And I have to admit, I was a little aghast at how intrusive it was, but being a good coastie, I did my research, looked up some information on OGE's website, did my reviews, put it away, and then forgot about it until the next year when my boss came walking in and dropped a bunch of 450s on my desk again. Of course, I'd forgotten all about it, so I had to refresh my recollection, but we managed to make it through. A little bit more background. As part of our process, we use the filer supervisor as an intermediate as part of our review process. As my boss said at the time, "I don't know what they do," referring to the filers. When I look back at it, we never gave the supervisors, or quite frankly, the filers, any training. And the years that I did it, no supervisor ever came to me with a question. I'm pretty safe in saying that mistakes were probably made with 450s during my watch. But thinking back on it, it would have been a lot better if we had at least talked with the supervisors, gone over the process, and let them know what we were doing. I know that you as supervisors are busy, but this is a requirement, and we don't want to read about our employees in the newspapers in a bad way. Okay, so let's move on. This is essentially an entry-level course designed for supervisors who will be responsible for doing the intermediate review of the Confidential Financial Disclosure Form, the OGE 450. Basically, certain executive branch employees, because of their duties and responsibilities, have to report their personal financial holdings, and their agencies have to review and certify these reports. The main purpose for this is to avoid a conflict of interest, and we're going to talk more about that later. If you are listening into this, You are hopefully a supervisor who has subordinates who file 450s, and your agency has already determined that you should be part of that review and certification process.
Yeah, and Mark, and for the folks that are on the broadcast who are ethics officials, this is going to be available on the IEG YouTube and Google Plus pages. So if your supervisors weren't able to join us today, they can do so in the future, and you can use this in future filing cycles. So we have added value there.
Great, great. Okay. Also, I'm going to presume that you are also a filer yourself and are already familiar with the financial disclosure forms. But if not, I'm going to be throwing a lot of new terms at you that you may or may not be familiar with. Hopefully, we'll go over them during this training. And but please feel free to ask questions if you're not familiar.
And those folks who do want to ask questions, if you are on the Hangout, you can ask questions using the question app in the lower right-hand corner of your screen. Alternatively, for the folks on the phone, we will have a Q&A at the end.
Okay, course overview. Essentially what I intend to do here is do a brief overview of the Executive Branch Financial Disclosure System. We're going to then take a look at the 450 form and its reporting requirements, and we're going to talk about remedies for potential conflicts. We will just be going over the basic process. If during your actual review you come across an issue or situation that you have questions on, we will recommend that you go to your agency ethics official. First off, let's make sure that everybody has the handouts. It should be just a copy of the PowerPoint that you're looking at now, a blank or unfilled copy of the 450 form, and a one-page handout on remedies.
And if you don't have those are available for download on the Max registration page where you registered for this course.
Okay, I'm looking at the next slide now. Just to put things in perspective, let's talk a little bit about OGE and its relationship with your agency. OGE is essentially just an oversight agency. We provide guidance and advice to other executive branch agencies. Now, as part of that oversight, we promulgate regulations on ethics issues, including regulations on financial disclosure. However, each agency is responsible for its own ethics program, which is run by its designated agency ethics official, or DAO. And you'll hear me use variations of that phrase throughout the training. So if you have any sort of ethics question at your agency, you should make full use of your agency ethics official for help. The exact setup that you have may depend on your agency. Usually it's within the local legal office, but it may be centralized at a headquarters level or something in between. Whatever process you have at your agency, please use that. Now, I used to be a desk officer here at OGE, and they are the first point of contact at OGE for your agency ethics officials. If they have any problems, they come to us for guidance. We also have a review section at OGE, and they come out to the agencies and actually review their ethics programs to ensure that they are in compliance with the OGE regulations and the statutes. As part of that, they will actually look at the agency's financial disclosure forms to ensure that they're being used correctly. Now, the basic purpose of all this is to ensure that we all work together to make sure that your ethics program is running as smoothly as possible in order to better serve and protect your agency employees from potential ethics issues or problems. Okay, now let's talk a little bit about financial disclosure. Basically, public service is a public trust, and all federal government employees are held to high ethical standards. As part of this, certain federal employees, because of their positions and duties, have to file financial disclosure reports with their agencies that report their personal holdings. And trust me, they don't like it. There are two types of reporting systems. The 278 is actually a public form. It's releasable to the public. And the 450, which we're going to look at today, is a confidential form. It's not releasable to the public. The 450 is, the 278 is essentially for more senior personnel, and the 450 is for less senior personnel, but who do have duties and responsibilities that may make them more prone to conflicts of interest. Because remember, the underlying criminal statutes apply equally to all employees, whether or not they file.
And if you're curious about who should be filing an OGE Form 450, we do have a guide to help you make that determination, and you can find that in the store on the IEG Manx community.
Also, just a reminder, filing alone does not protect a filer. It is just considered a starting point for further review of a filer's holdings if necessary. Now, as a supervisor, you will be able to use the information from the form to both help you assign appropriate work to individual employees to help them avoid conflicts, and that will help you assist those employees in avoiding those potential conflicts. You should make full use of your agency ethics official during this process, but remember, you should not use the information in the form for any other purpose.
I think that's an important point, Mark, is that this is really a collaborative effort between the supervisor and the ethics officials. We're not expecting supervisors to be experts on the ethics laws and regulations, but we're using them as our eyes and ears for knowing what kind of work the employees might be working on that could potentially pose a conflict.
Absolutely, absolutely. And we're going to emphasize that throughout the training. Okay, now let's talk about the actual certification process. Essentially, we have to do this because it's the law. Now, how do we do this? As part of your agency ethics program, the agency has to have a written certification process by which it determines who must file a 450, how to collect, review, and certify those 450s, and how to maintain them. For your purposes, I'm assuming that your agency, DEO, has already set up this process, but since you are part of it now, you'll need to be familiar with it so you can understand your role. And once again, I want to emphasize, if you have any questions about your job or your duties in this, by all means, put your designated agency ethics official on speed dial. Make full use of them. They are the specialists in this area. Okay, first off, filers are responsible for filling out and submitting the form on their own, but the agency's process must include at least a technical review of the form to ensure that it has been filled out completely and correctly, and a conflict of interest analysis to determine if there are conflicts. And we'll talk a little bit more about the conflict of interest analysis later in this presentation. The concept of COI first. Essentially, that's an OGE concept, but it's one I wish I had used back in my agency days. In order to best protect your employees, you should treat this as a request for advice, but essentially they all come in at once. What you may want to consider is perhaps reviewing your problem children first. For example, I had a filer whose spouse was a day trader. So that 450 was about 3 inches thick. Trust me, it would have been better for me to review that one first for potential conflicts rather than just do it in the order that they came in. Or you may want to just skim them all to see if you see any problems. But basically, this is just a suggestion, not a requirement. You handle it as you see fit. Also, the form is a bare minimum reporting requirement. You may need to get information later. Agencies have to deal with their potential conflicts by using remedies. We're going to talk about that later in this presentation. Then the agency will certify it by signature. They have to do this within 60 days, and then the files are retained for 6 years. Once again, as a reminder, the purpose of this, we're looking for potential conflicts of interest. We hope to get this and remedy it before the filer takes an official action, because if we have an actual conflict of interest, then we're dealing with a crime. It has to be investigated and referred to the Department of Justice.
We'd rather get there before we need to involve the Department of Justice, right?
Absolutely, absolutely. That's why we're here. Okay, now let's talk about the legal basis for review, which you should be at least aware of, if not totally familiar with. what we're looking at are the criminal conflict of interest statutes, and then OGE's regulations, and then any agency requirements that you may have.
So those would be things like supplemental agency regulations or prohibited holding statutes, things like that.
Exactly right, Patrick. Okay. Let's take a look at the next slide. And you don't have this in your materials because I really thought that as supervisors, you really don't care. We're just going to go over it briefly. And once again, remember, if you have any issues, go to your agency ethics official. And also, this is just an overview. This is just a summarization of the actual criminal statute. Okay, the first one is 18 U.S.C. 201. Essentially, it prohibits a bribe. And that's really not why we're here, because all the forms in the world won't stop someone who wants to take a bribe or wants to steer a contract to a brother-in-law or something like that. And when I do my basic training, I refer to the story of Randall Duke Cunningham, who was a congressman from California who actually used to write out the amount of the bribe necessary to get a particular government contract on his congressional stationery. He, of course, ended up in jail. Last I heard, he's out of jail now. But we're not dealing with that. We're dealing with the 99% of federal government employees who just want to come in and do their job. The next two are sections 203 and 205. These essentially prohibit federal government employees from representing outside entities back before the federal government. This may seem like it's not a big deal, but it can happen inadvertently. When I was in the Coast Guard, I had a junior officer who wanted to set up a floating museum back in his hometown, which was great. But as he was walking out of my office, after we gave him permissions and all that stuff, he said, great, now I can sign that letter to XYZ federal agency to get the money for this. And I had to say, whoa, 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 wait, come back. You can't do that. That's against the law. So once again, best of intentions, but it could have been a problem. 207, it prohibits people from representing, former employees from representing back to the government. It's not a concern for financial disclosure, but it's good for you to know as a supervisor. Once again, my Coast Guard story is about a retired contractor who wanted to come back with his new employer onto the Coast Guard base and just sit in the room while they discussed an upcoming contract. And my boss said to me, if he tries to get on base, have him shot. Okay? And you can understand that was a big deal for me, because we're the Coast Guard, we save people. But even just appearing in the room would have been of potential, if not definite, conflict with breach of 207. Section 208, this is our main conflict of interest statute. And I'm going to read it real quick, or read the summary real quick. Essentially, it bars an employee from participating personally and substantially in an official capacity in any particular government matter that would have direct and predictable effect on his own or his imputed financial interest. Well, for the attorneys out there, you realize that's about 7 elements that have to be proven in order to convict somebody under that. But it has happened, and this is our main issue here.
So this is what we're really looking at with the 450 primarily, is potential financial conflict of interest between the filer's holdings or other reported entities and their duties. So as a supervisor, what would I want to know? I want to know if there's a nexus between the filer's responsibilities and the items reported on the 450. That's what I'm looking for 208.
Absolutely, and we're going to go into that in a lot more detail later. But basically, yes, if the filer can take an official action, presumably through his duties or job, that affects his or his imputed financial holdings, then that's a violation of 208. And we're going to talk a little bit more about imputed interest in just a second. Once again, the vast majority of our federal government employees are honest. They just want to come to work and do their job and then go home. However, employees can violate this inadvertently. So that's the thing we want to avoid. Okay, quick story. Marvin Runyon at the Postal Service was the postal director, had a great idea. Let's put soda machines. Let's put let's put soda machines in every post office. That was great, except he recommended specifically Coke, and he happened to have stock in Coke, a lot of it. So when that got out, obviously the value of Coke went up, and he technically violated 208. It was referred to DOJ. They decided to prosecute. It was settled. It was a big deal, but that's what we're going to try to avoid. Section 209, essentially, you can only be paid by the federal government for doing your federal job, and we generally don't need to worry about that. Okay, now let's talk a little bit about imputed interest, because this usually gets a lot of attention from your filers. Spouse, minor child, general partner, any other outside interest or potential future employment. This is all those interests are directly imputed to the filer. We tend to see people getting a lot of pressure or pushback from the spouse who says, I don't work for the federal government. Well, this was litigated all the way up to the Supreme Court. They denied cert, so this is just what we have to deal with.
And this is for Section 208, is that correct, Mark? So these are the people whose interests we treat as the same as the filers for purposes of the conflict of interest law.
That's correct, Patrick. And we're going to talk about the standards of conduct imputed interest a little bit more later. Okay, this slide is OGE Regulation 2640. This is the main 208 implementing regulation. You as a supervisor really don't need to be concerned about this, except I just want to draw your attention to Section B, exemptions. One thing to know is that 208 has no de minimis. If you have any financial holding in an outside entity, that's it. However, OGE has determined that some holdings are too remote or inconsequential, and so would not be a conflict of interest. If this issue comes up to you with one of your employees, by all means, go to your agency ethics official and get it resolved.
Yeah, in my experience, these can be a little bit tricky. So if you don't have a lot of experience or familiarity, it's really good to get the advice of someone who does.
Absolutely, absolutely. Okay, let's move on to the standards of conduct regulations are also from OGE. They apply to all federal government employees, but you may want to remind your employees if you need to contact them during your review. Believe me, when I first started here at OGE, I know I was given a copy of the standards and given time to review them. I probably have very little recollection of that. I'm sure most federal government employees are the same way, but still, hopefully, they're aware of them and use them in their daily work. In addition, the gift issues in Subpart B and C may come up during your review. But now let's talk about Subpart E, or 502, as we refer to it as impartiality. This imputes more interests of others to the filer. It's similar to the conflict of interest concept, but it goes beyond the reach of 208 imputed interest and also is obviously not criminal. But it puts the burden on employees to assess whether a reasonable person would question their fairness in their government duties. For example, you may assign an employee to a particular job, and that employee may come back and tell you that they can't work on the job because they have an impartiality concern based on a covered relationship. Or you may know some information about the filer that makes you concerned. For example, if you know that the filer's spouse is applying for a job with a contractor. If that sort of issue arises, by all means, get your ethics official involved. Hopefully all of your employees have been thoroughly briefed and trained by your agency ethics official, and they're all aware of the requirements of the standards of conduct.
And the request to file in the filing season is a good time to remind people of their obligations under the standards and the criminal conflict of interest laws. So if you have filers who are saying, why do we have to do this? What rules require it? It can be a good idea to remind them that the criminal conflicts of interest laws exist and the standards of conduct apply.
Absolutely. And also, if you're looking for training subjects for your employees, ethics is always a good one. Okay, let's talk next about employees required to file. For filing the 450, generally it's GS 15 and below, and it's based on their duties. The agency makes this determination and has a list of filers which must be and is also required to be produced if OGE does a program review.
And I think this is a really important feature of the program, Mark, that the agencies determine who they need to file. So the agency should do an assessment of which employees are most at risk for potential conflicts, and where they find those people, those are the people who should file. Is that correct?
That's absolutely correct. And generally, that's been determined by the agency. But the reason I bring this to your attention is that as a supervisor, you may feel that certain employees have duties which you feel should require them to be subject to financial disclosure reporting. Conversely, you may feel that you have certain employees whose duties do not require financial disclosure reporting. In any event, you should consult with your agency ethics official.
Yeah, and I know when I was an ethics official at an agency, we enlisted supervisors frequently to help us determine who should file. And that's for the same reason we enlist supervisors for the intermediate review. They're the people who know what their staff members are doing.
Absolutely. And just to follow on with that really quickly, back in the 90s, OGE came out with some guidance which tried to educate agencies about who should file. And of course, the agency response was, well, fine, we'll just make everybody file and then we'll get back to work. And then OGE actually had to come out with subsequent advice saying, no, that's not what we intended. We don't think that everybody should have to file. And in fact, here at OGE, desk officers don't have to file because we deal with outside entities, but we can't impact them. One other quick story. Back in my Coast Guard days, one of the people from my legal office went to be the commanding officer of a supply depot and called me up and said, yeah, I have this person who works for me. I want them to be a filer. Well, he was senior to me, so I said, yes, sir, and that person was put on the list. Now, I don't know the underlying reasons, but I can safely bet that after 20 years, that person is probably still having to file. As a management tool for the supervisors, you may want to work with your agency ethics officials and vet the 450 filing list, because maybe you can reduce your workload and also get it to a more reasonable level about who really needs to file.
That's exactly right, Mark. We want everyone who needs to file, and no one extra.
Absolutely.
This isn't a make-work project. The agency has complete discretion to meet its needs, so we want the folks to file who need to file, and the folks that don't, we don't want them to file because they take valuable time away from other areas of the ethics program.
Absolutely, and your program as well. Okay, next, let's take a look at filer reporting dates. New entrants file within 30 days, but we recommend that they do so as soon as possible. In fact, we recommend that it be part of the application process. Now, why am I telling you that? Because as a supervisor, you could use this as part of your employment application process so that you can screen for potential conflicts even before someone is hired. You may want to know in advance if an applicant has conflicts that may impact on the job.
Yeah, I think that's really important. If you've been fortunate enough to get this far in your career and not have a situation where someone comes into your agency who has really difficult to manage conflicts or conflicts that are really going to disqualify them from their primary duties, that's a really uncomfortable place for the ethics office to be. The filer doesn't enjoy it either, so if you can identify and address those things and come up with some remedy plans before someone comes on board, all the better.
Absolutely. Next is the annual due date. It's on February 15th, presumably because everybody has their tax documents out so they know all their financial holdings. You, as the supervisor, may want to ensure that you are in the office during this time so you will be available for the review. Remember, the sooner we actually review the form, the better for the filer. And all this information is actually on the form. Agencies can grant extensions in certain circumstances, but if you have an employee who asks for an extension, by all means deal with the agency ethics official, as they are the ones who have the authority to grant the extension. Okay, now let's talk about the actual 450 form. It consists of a cover sheet, 5 parts with different reporting requirements, and an example page. It also contains instructions for the filer. You as the supervisor and reviewer should be familiar with this in order to assist you in your reviews, and we're going to go over it. The OGE Optional 450A. This is an OGE variation. Essentially, annual filers who have no new interests and no change in their positions or duties may use the optional form for up to 3 years in a row. It's a one-page form. It was developed by OGE to reduce the workload. However, it is up to the agency to determine if they will allow filers to use the optional form at all. In the Coast Guard, we used it as much as we could because our long-term civilian employees were typically procurement specialists who'd been in the same job for 30 years and never had any new interests or anything like that. But as the supervisor, you may prefer to minimize your reviews just to save your workload. However, it also means that for those periods, you are not seeing anything about that filer as you do not sign off on the form. However, this is going to be set up between you and your agency ethics official. Okay, to sum up, this is the basic information that the reviewer, in this case you as a supervisor, needs to know to do their review. As the supervisor, it's assumed that you know the filer's name, his duties, and his filing status. In addition, it's also assumed that you would know about the filer's spouse and dependent children interests. After you review the form and compare the duties to the reporting holdings, you may find potential conflicts. If so, you may need to be able to recommend appropriate remedies for both the filer and you as the supervisor. We'll talk about remedies later, but if you do find a potential conflict of interest, it's usually a pretty big deal since we are dealing with a criminal statute. First, tell the filer not to take any official action. Then contact your local agency ethics official and, if necessary, any other parties and get it resolved. But what I want to emphasize there is don't let the employee take any action on a matter if you think it's going to be a conflict. Remember, our main purpose here is to help our filers avoid conflicts of interest, but we still need to get our agency work done. So I realize this is kind of a hassle. Incomplete information. Essentially, initially we assume that what the filer has told us is correct. However, if there are blatant errors or if we are aware of issues, you are required to go back to the filer and get them resolved before you can sign off on the report. In addition, an entry may be sufficient for reporting purposes, but you may need to get additional information for any potential conflict of interest purposes. Just reporting a holding doesn't mean the filer is okay. Remember, treat this as a request for advice. Also, OGE recommends that you annotate the form with any changes and that you maintain a file of your correspondence with the filer. The OGE reviewers will look for this, and your comments will demonstrate any action that you took. If you have to go back to a filer, this will toll that 60-day period because you reviewed the report and now you're just working on the information there. When you go back to the filer, remember that you do not have an attorney-client relationship with the filer. This is especially important for the attorneys out there, and this can be awkward. If the filer reports to you that there is essentially some wrongdoing, you have to refer that on. This can be very awkward, especially for you as the boss. You may want to work more closely with your agency ethics official on this and let them do the talking to the filer. Just a thought. Obviously handle it however you do at your agency. Okay, let's look at the information that the filer is going to be reporting on the form. Back in the day, Congress did a balancing act between the filer's right to privacy and the public's right to know about conflicts of interest, and OGE modeled the 450 on that. Specific requirements and exclusions are on the form and in the regulations, and also not all parts apply to all filers. What I'd like you to do now is take out the actual 450 form and take a look at it. The first page should be just the cover sheet, and it just contains the basic reporting requirements we just went over. These are instructions for the filer, and this page does not need to be retained in your records. One thing to think about for your filers is penalties. Employees have been fired under circumstances that included failure to fill out the form completely. Oops. The next page is the information page. This is where the filer reports his or her name, position, and contact information. On the top left, where it says date received by agency, that should be date stamped when it comes into either your or the ethics office. That starts the 60-day clock, and reviewers will check that. Below that is the employee's contact or employee's information, including contact information. And obviously this, you're presumably familiar with the agents, with the filer. Right below that block are a series of steps. The filer is required to give an initial report of holdings based on those steps. If the filer checks the yes block on the right-hand side for one of those steps, then the filer has to fill in the specifics in that part. The filer then signs and dates the report. Now, if the filer reports no for all parts, and you're comfortable with that, then only this page needs to be retained and no further review action needs to be taken. Otherwise, only retain those pages that are used. Excuse me. And once again, the reason you're here is that your agency has determined that it's better to have the supervisor involved in this process since you have a more thorough knowledge of the filer's work responsibilities. So the block I'm looking at now is right below the signature of employee, where it says for reviewers' use only. Where it says signature and title of supervisor / other intermediate reviewer, if required by agency, that is where you will sign. And please note it states, on the basis of information contained in this report, I conclude that the filer is in compliance with the applicable laws and regulations, except as noted in the comments box below. Your signature there is kind of a big deal. It's part of the certification process, and we'll talk about this more as we go along. Below that is the comments section. If you do feel the need to make a comment on a report, you could either make it there or make it on the particular part of the report. Okay, let's talk about part 1 of the form. This is where the filer reports assets and income, and the specifics are on the slide and on the report. Essentially, we're looking for anything held for investment or the production of income. When we talk about income, we either talk about investment or unearned income, interest, dividends, capital gains, etc., or earned income, which is non-investment income, salary, wages, fees. We also talk about honoraria because the spousal honoraria has a higher cutoff than other sources of spousal non-investment income. This is designed to make it a little bit less intrusive on the filer. Once again, the only reason I'm telling you this is that you may want to be aware of this if an issue comes up with one of your filers as to what's reportable, and by all means, take that question and go to your agency ethics official. There are also exclusions, and we will talk about, and exemptions, and we will talk about them in just a second. Assets and income typically are a main source of potential conflicts of interest, so you need to be aware of that as well. Okay, while you don't need to be a financial expert to do the review, you need to be aware of some financial concepts for reporting purposes. Trust me, I'm not an expert, but I know people who to go to. Let's talk about the concept of investment vehicles or holding entities. Certain investments may have underlying holdings. What we need to do is break those out, because those underlying holdings are what we base our conflict of interest analysis on. However, certain investment vehicles do not need to be broken out. Common investment vehicles are IRAs, 401ks, TIAA-CREF, 529, and variable annuities. These are examples of investment vehicles whose underlying assets need to be broken out.
I think this is an area where we see the most frequent underreporting by filers is the failure to include the underlying assets of the 401ks and the IRAs. So this is just something to be especially on the lookout for.
Absolutely, Patrick. And basically, if you see this, just somebody write down IRA and you don't see any underlying assets, you will have to go back and get more information. And once again, I can safely tell you that when I first started doing financial review back in my agency, I did not know that. But what I can safely say is that all my sins have been destroyed since they're more than 6 years old. But hopefully, with our little training here, you as the intermediate reviewer will not make the same mistakes that I made. Once again, if you have any issues or questions, well, first, actually, you could just ask the filer, or you could do a little internet research on your own, or you could just go to the agency ethics official and get their advice. The next financial concept I wanted to talk about is mutual funds, which are a very common entry. Basically, there are two types of mutual funds. They're either diversified or sector mutual funds. A mutual fund itself is a very, very common holding, but the filer just owns the share and doesn't actually own the underlying assets. So OGE has determined that the underlying assets do not have to be reported. In fact, OGE has further gone on to say that diversified mutual funds don't have to be reported at all because they're not going to be a conflict of interest. But sector mutual funds, which concentrate in an industry, business, or foreign country, do have to be reported, even though their underlying assets do not have to be reported.
I think this is really important. We changed the policy back in the early 2000s not to require reporting of the diversified mutual funds. And the question that I always get at this point in classes and lectures when I talk to ethics officials is, well, do I have to go back and take off all of the diversified funds on the 450, or can I just leave them as over-reported and let people know next time that if they don't want to have to report them, they don't have to? Do you have a sense of what folks are doing, Mark?
Yes, absolutely, Patrick. While we here at OGE live and die by ethics, we sort of noticed that at the agency level and the filer level, they don't care as much as we do, and this is designed to be simpler and less intrusive, but the filers just report everything that they have.
Right, so if the filer doesn't want to decide, I don't know if this is diversified or sector, I'm just going to put it on there and be done with it. We don't need to spend our time going back and whiting that entry out because these are confidential reports, and we're going to see them, the ethics official is going to see them, and the filer, so the over-reporting isn't such a big deal. Exactly.
We would call this harmless over-reporting. Unfortunately, it puts a little bit more burden on the reviewer because they have to look through and find out which mutual funds are sector funds and whether or not they're a conflict, but that's kind of a de minimis issue.
Yeah, I'm not sure we actually made things easier for ethics officials when we made that change. But they asked us, they said that they are spending a lot of time going back for the full names of obviously diversified mutual funds. And we said, well, those are exempt under 2640 anyway. They don't have to be reported, but we didn't intend to create a make-work project of going back and whiting out the diversified funds.
Absolutely. Absolutely. Let's try to minimize the extra work. One other financial entity that I think you should be aware of, which I was not, of course, back in the day, retirement plans of people who worked in the private sector before coming on to federal service. The defined benefit plan, it's the older, more traditional type. An employee works for a company for 30 years, retires, and then gets a guaranteed payment of $1,000 a month. The filer does have to report the plan, but no underlying assets, because there are no underlying assets. As long as the company stays in business, the filer gets the money. More common these days is a defined contribution plan, for example, the 401k, where both the employee and the company pay into the fund. The employee selects the underlying holdings and hopes for growth in value of the underlying funds for retirement income. Those underlying holdings have to be broken out. Usually this is screened for our new entrants, and then we just know about it year by year. But if you have a new entrant from the private sector and you don't see any pensions, you should probably go to your agency ethics official and track that down.
Yeah, because we usually expect to see when someone's coming in from the private sector that they have a 401k or another kind of retirement plan. And again, we need those underlying assets so we can do our conflicts analysis.
Absolutely. Okay, let's take a look at the actual form. And this, once again, is your handout. What we're looking for is essentially listed in the instructions for the filer. Basically, we're looking for stocks and bonds and sector mutual funds, plus the underlying holdings of other investments and defined benefit plans. Once again, we don't report diversified mutual funds. Also to the right, we don't report anything from the federal government or any cash account.
Well, that's because those things can't pose conflicts of interest, right?
Absolutely.
Because again, the purpose of this is to prevent conflicts of interest, and if we have things that can't pose conflicts of interest because they've been exempted or they just never could pose a conflict, we don't need to see it.
Exactly, Patrick. Just too remote a possibility. Right below that is where we talk about reporting income. Once again, the spouse has a higher cutoff rate. Once again, this is designed to be less intrusive, except for honoraria. We don't care about dependent child's earned income or, once again, any other federal government benefits. Now, below that are some definitions. So if you're concerned about a diversified mutual fund or a sector mutual fund, there's some help there. If you have a filer who is concerned about the status of a dependent child, there's some guidance there as well. But once again, if you have any questions, go to your agency ethics official. Okay, below that where it says reportable information, essentially we need the name of the asset, but the filer may also add a ticker symbol. If the asset is no longer held, for example, if it had been divested per an ethics agreement, then the filer would check the no longer held block. Now let's go to the back of the form. And the last page of the form is the examples page. And once again, you don't need to retain this for your records. I just want to go over it now so we can see examples of what a technically sufficient entry is. And you can see that OGE has listed out there examples of a sector mutual fund, example of a stock held in a 401k plan, even though it doesn't specifically say that there. Typically, somebody will write down something like 401k, and this lists those particular holdings beneath that. They don't have to. We really don't care about the 401k. We only care about the underlying assets.
So we care about what's in the 401k. The fact that it's in a tax-advantaged account doesn't make much difference to us in our conflicts analysis.
Exactly. Okay, so let's start with our technical review. What do we do when we get a form? Essentially, we want to make sure that the filer filled it out correctly and completely and did include underlying holdings. Potential things to consider. OGE recommends that you compare the current annual report to the prior report. If there are no changes in the holdings and you as a supervisor know that the filer's duties haven't changed, then boom, there's no need to continue your review. You know that there are no new potential conflicts of interest. Again, we take the report at face value. We assume that the filer has read the instructions and filled it out. However, if you have any independent information, then you will need to track that down. For example, if you happen to have been in the break room and heard one of your employees bragging about how his wife received a big inheritance from his mother-in-law consisting of stocks and bonds, then they should appear on the next year's report. If they don't, then either you or the agency ethics official should follow up on that.
And I think this is a good training point for employees when their financial situation changes significantly, even if that's not during the filing season. It's never a bad idea to go to an ethics official to find out if your new situation or your new holdings are likely to pose any potential conflicts of interest. So, when we have a change in responsibilities or a change in financial picture, it can be good to get some supplemental advice regardless of the filing season.
Absolutely. Hopefully, once again, your employees will come to you with questions like that, and you have your ethics official on speed dial, and everybody can talk everything out before we have a conflict. Okay, for our conflicts analysis, this is the primary purpose of the review and certification of the report. The question is there a conflict between a holding and the filer's duties? Can the filer take an official action which would have an impact on his and her holdings or his and her imputed financial holdings? If you see such a scenario, once again, tell your employee not to take any official action and then get everybody together with your ethics official and talk it out. Now, a prohibited source is from the gift concept into the standards of conduct. A prohibited source is essentially somebody who does business with your agency, wants to do business with your agencies, regulated by your agency, et cetera, et cetera. And a prohibited holding is an asset that is prohibited by an agency-specific statute, typically your organic statute, or any other agency regulation.
We see that a lot with agencies that regulate the financial sector, where they have a significant list of prohibited holdings for all or some employees. So if you're not sure if you have those restrictions, you should find out. Normally, agencies will maintain a list or a description of things that are prohibited.
Absolutely. And presumably, since you're part of the review process, your agency ethics official has already let you know that. But if you're not sure, by all means, ask. Okay, let's go on to part 2 of the 450, which is liabilities. Essentially, liabilities, debt or money owed to an outside entity or person. What's reportable is anything over $10,000 owed at any time during the reporting period from a bank or financial institution on unusual terms. And by unusual, I usually mean favorable. So if you have an employee who's getting a sweetheart loan, that's reportable. Or any liability over $10,000 from an individual. Okay, and once again, this does apply to the filer's spouse and dependent children, and there are exemptions.
And here, what are we trying to detect, Mark? Is it a concern that maybe someone would have a gift that's taking the form of a loan?
Absolutely, absolutely. Well, let's take a look at the form itself, and let's try doing our technical review.
Okay.
First, we make sure that it's filled out completely and correctly, and then we do our conflicts of interest analysis. Interestingly, back when I first started working at OGE, I saw an MSPB case where a federal government employee was fired for not reporting a mortgage on a 450 form. There were other issues, of course. In fact, the employee worked for HUD and had circumvented HUD's system to illegally get a new house or a second house and didn't want HUD to know about it, so obviously didn't put it on the 450 form. We're really, if somebody's that egregious, they're not going to put it on the form, and they'll be caught in other ways, as this filer was. However, commercial debt is really less of a potential for a conflict for most government employees, but it's still a reporting requirement. Obviously, if you see that your employees are getting loans from contractors and reporting that, you probably want to look into that really, really quickly.
because that could be that could constitute a prohibited gift or a supplementation of salary or some sort of other prohibited gratuity if it were a favorable loan from someone who does business with our agency.
Absolutely, Patrick. Absolutely.
Excellent.
So let's take a quick look at the examples on the last page of what a technically sufficient report would be. We have the name of the creditor, John Jones. We have the type of liability, personal loan from a friend. That's fine. We can work with that. The one below that, with an investment company and a margin account, that may get a little bit more of your attention. Back on the form itself, there's actually a typo. The form says financial institution or business, and it should say bank or financial institution. If any question comes up with anything like a margin loan, which is essentially an agreement with a stockbroker where the stockbroker has your permission to buy and sell stocks or other holdings, and then you just pay the stock, the investment company, there's a stock broker back. That has a little bit more of a potential for a conflict. By all means, bring that to the attention of your ethics official. Okay. Let's go to part 3, and I'll try to pick up the pace here. Part 3 concerns outside positions. What we're looking for are positions of financial interest or fiduciary responsibility in outside entities. We really don't care if it's paid or unpaid. We just want to know what the outside entity is and what the filer's position is. This applies to the filer only, and once again, there are exceptions. So let's take a look at the form and see the information there. Essentially, we want all positions outside the U.S. government held at any time, but we don't care about positions with a religious, social, fraternal, or political entity, and we don't care about anything you hold in your official duties. For the reporting information, what we want is the organization, including the city and state, the type of organization, and the position. Obviously, an outside job with a contractor or a board membership with an entity that is seeking to do business with our agency, we could see some potential conflicts there. Also, for our training, we're going through this one part at a time, but when you review it, you see it as a whole, and some information is reflected in more than one part. For example, if our filer had an outside position that was paid and it was over $200, then that should also be reflected on part 1 as earned income. Finally, well, not finally, excuse me. Also, many agencies have requirements that an employee obtain permission for an outside position in advance. If your agency has that, and we did in the Coast Guard, you should know that. And if you see something on a report that you're not already familiar with, that your ethics official hasn't told you about or was not on the prior year's report, then you should clear it with the agency ethics official and the employee.
Yeah, I think that's really important here, Mark, that we enlist the assistance of an agency ethics official when we see an outside position that hasn't been looked at before. When I teach the outside activities advice and counsel course here at OGE, it takes us 2 or 3 hours to go through an analysis because there are a huge number of laws and regulations that are potentially implicated by an outside activity. So this is an area you really want to get some help, because even if someone's very experienced with the ethics laws and regulations, it still takes some time and energy to work through.
Absolutely, Patrick. And one of the main issues here is that the Office of Legal Counsel at the Department of Justice came out with an opinion, I believe back in the late 80s, early 90s, where it specifically said that federal government employees essentially can't have two masters. You can't have an outside position and a federal government position. And of course, when that came out, there was a lot of consternation in the federal government. And for the Coast Guard, it meant that we had to have a lot of people resign from their outside positions and then go back as either a non-voting member or ex officio or something like that. So based on that OLC opinion, it's really easy for somebody to get into trouble if they don't remember that and they go out and they sign up for an outside organization. It's fraught with peril, and hopefully they're talking to us about it.
Yeah, and that's why we tend to have those prior approval requirements, is because it's an area where people can easily run afoul of the rules, and it's important just to get the appropriate advice and guidance before moving forward.
Absolutely. Hey, the more we talk, the better. So that's another point we like to emphasize here. Okay, and once again, there are examples of what a good outside position would be. Well, sorry, not a good, a technically sufficient outside position would be. A position that is no longer held at an educational institution. Presumably that's somebody who's either on a leave of absence or has come into federal government service, a family trust, or the membership of the board of directors of a Scenic Rivers Association, a nonprofit environmental organization, which may or may not pose a potential conflict with our agency, so we would have to look into the specifics of the filer's duties.
So it's a supervisor, Mark. When I'm looking at this, the first thing I'm going to ask myself is this outside position one that's been looked at by the ethics office and approved? And if it hasn't been, we're going to make sure that the employee takes steps to get that approval and that advice and counseling. I'm also looking for any nexus between the work of the agency and the outside employer. And if I see that, I need to be particularly concerned and maybe act even faster to enlist the help of the ethics official.
Absolutely, Patrick. And once again, just a reminder of the story that I told earlier about my junior officer who wanted to set up that outside organization to make a floating museum. He had gone through all the permissions. We were working together in the legal office to make that happen, and he'd done what he had to do. The subsequent problem would have been 203 or 205 representation back to the government. Once again, that was my bad. I should have given him more and better advice on that issue. We did nip it in the bud, but that's the type of situation we might see. And you as a supervisor, if you see that, you want to keep your people out of trouble, by all means go to the ethics official and get that resolved.
Excellent, thanks.
Sure. Okay, let's move on. Part 4. Here we're concerned with agreements and arrangements with past, current, and future employers of the filer. Okay, for future employment, the filer has a 208 relationship with some future employers. The filer has a full 208, or as we indicated before, criminal relationship with future employers. You as the supervisor should know that some future employers require that the filer get a safe harbor letter from the agency. That's where the filer comes into the legal office or the ethics official and says, I want to get this new job. They make me get a letter from you before I can start work. I want to start work tomorrow. Can you handle that? And you as the ethics official say, yeah, sure, fill out this form. And then they get all mad. However, it is a requirement that the filer not take any official action that would impact a future employer. If you see something, if you as a supervisor see something on the form indicating that, or you actually have personal knowledge of that, you should ensure that your employee gets appropriate ethics counseling. People can get into trouble with this. Does anybody remember the Diane Druyan case? Obviously, she didn't seek ethics advice, and in fact, I think was actively avoiding it. But because of her interactions with her future employer, she ended up in jail, and everything was bad.
This is an area we also want to be very careful about, because people notice when there's a problem with a future employer, because eventually that employee ends up working for the future employer. And that's kind of a visible way to see a conflict in retrospect. So the odds of detection in these cases are pretty high. So I always encourage employees to enlist the help of an ethics official early and often in the job search process.
Absolutely, absolutely. And presumably they're letting you know that you as a supervisor know that they're searching, and you can be a part of that process as well. For former employers, the filer must list any existing connections or relationships, for example, pensions or severance pay. This is usually less of a concern as the issues are typically worked out when the filer first comes into federal government service. Oh, Darlene Druyan. Did I pronounce that wrong? I'm sorry.
So sorry to Diane Druyan, whoever that might be.
Didn't I say Darlene? My bad. My bad.
It's the other D name. Yes. Darlene Druyan was the Air Force official who was prosecuted for seeking employment or negotiating for employment conflict of interest.
Absolutely. Okay, leaves of absences are common with typically college professors who come onto federal government service for a set period of time and intend to go back to academia. Once again, this is usually less of a concern because it's all been worked out when they first come on, and hopefully they've been counseled. One real quick story, we had a chief warrant officer in the Coast Guard who was actively looking for future employment and wanted to stay in Alaska, and he took official action that benefited his future employer. Unfortunately, when this was found out, it was referred to the Department of Justice, they prosecuted him, et cetera, et cetera. Look, he was a Coast Guard chief warrant officer. He was not a master criminal, and he didn't intend for any of those things to happen. He was just focused on getting a job because he wanted to stay in Alaska. If his supervisor had known the situation, obviously that all could have been avoided. So just one thing to think about for the supervisors. Ooh. Okay. No, actually, yeah, I messed that up. Oh, there we go. Thank you, Patrick. Okay, so let's take a look at the form. Essentially, it's the information that we just went over. It does not apply to the spouse or dependent children. The required information is the entity, including the city and state, and the terms of an agreement or arrangement. Let's take a look at the examples for part 4. Excuse me here. And the examples show how a technically sufficient report of a defined benefit plan with a former employer is reported, and how the filer reports an agreement for future employment. Obviously, the dates are incorrect on that example, but you can see that your filer has an agreement and is starting work, and you as a supervisor wouldn't let that person work with Hartford and Brown for the rest of their federal government employment. Okay, let's go on to part 5, gifts and travel reimbursements. Basically, a gift is a thing of value. A travel reimbursement is when the donor subsequently pays the filer for the cost of travel. The only reason we differentiate that is because they have separate aggregating requirements. It does apply to the filer's spouse and dependent child. For technical review, once again, if you have any question about what a gift is, the definition of a gift, take it to your agency ethics official. The gift amounts change every 3 years. It's kind of a pain, but your ethics official will track that for you. There are some exemptions, and once again, remember our standards of conduct gift issues. What we're talking about here is just reporting of gifts. We'll talk about standards of conduct a little bit more when we talk about remedies. Essentially, what we're looking at is the gift a bribe in disguise, or is it meant to influence our employees' conduct?
So we're looking for things that might be from a prohibited source or from someone that our agency does business with, or gifts that are maybe given because of the employee's official position.
What are some?
No, but those are the kinds that we'd be
yes.
concerned about. We could have lots of gifts that are completely innocuous, like someone receives a large birthday present for someone unrelated to the agency. That could be reportable, but then we're not concerned that poses a problem under the standards of conduct because it's not given because of their official position or from someone that does business with our agency.
Absolutely, thanks, Patrick. Let me emphasize that we're talking just reporting of gifts, and essentially, unless there's an exception, then the gift has to be reported, whether or not it's a conflict or whether or not there's a problem under the standards of conduct.
That's an interesting thing that always comes up at this spot in the courses. So you have employees who think they only have to report gifts that are prohibited by the standard of conduct or a bribe or something. Actually, what we're trying to do is capture gifts, and we hope not to see any gifts that violate the standards of conduct.
Absolutely, absolutely. And if we do see that, then we have to go back to the standards of conduct to determine how to resolve those gift issues.
And I think, if you see something that causes you concern immediately, ask the ethics official, because it's very likely that the employee has been issued an ethics opinion to allow them to accept that gift, and we can save a lot of heartburn by checking for those opinions.
Absolutely, absolutely. And once again, there are the exceptions that are listed on the form. You remember my scenario before about somebody inheriting particular holdings? That's not technically a gift, but it would have to be reported on Part 1 if it was otherwise reportable, for example, stocks and bonds and things like that. Obviously, if your employee is reporting large gifts from a contractor, you might want to look into that. Let's take a look at the examples. Thank you. And you can see our example is the source of a leather briefcase, and below that, a travel reimbursement from a culinary institute. Technically, that's sufficient. If we know that D. Jones and Smith is a contractor, we might want to look into it. If our agency has any interaction with the Culinary Institute, we may want to look into that too. Obviously, as a supervisor, if you see your employee getting gifts like that, you're going to be concerned. Okay, that's it for the form. But if you did see an issue, what would you do? And once again, hopefully, the walkaway point is you contact your agency ethics official. Remedies can be a big deal. We're talking about criminal statutes. It may require a written ethics agreement, and we have lots of OGE guidance on that. But by all means, first, tell your filer not to act. Then get all the parties together and resolve this.
I think that's a really important point. The first thing we want to do when we see a potential problem is ask the employee to stop participating.
Tell the employee.
Tell the employee to stop participating. And it may be the case that an exemption applies, or we can do some other remedy that would allow the employee to resume participation, but we want to do that in consultation with the ethics office.
Yes. And now if you could take a look at the handout that says remedies descriptions, it should be a one-page. The first option for a remedy is recusal. And by that we mean that the employee just doesn't work on the matter, which is easy for the employee. They just don't work on any particular contract or case or whatever led to the potential conflict. But for the supervisor, that may make things difficult. For example, if that was a repeat contractor, it may end up on the filer's desk by accident. You may want to set up a screening arrangement to ensure that those matters don't come before that employee. And by all means, you would use your agency ethics official to help set that up. Resignation. This means that the filer gives up an outside position or otherwise just leaves his government position. This can be ordered by the agency or mandated as a condition of employment.
And that's in the event that the outside position conflicts with the employee's duties so frequently that they're materially impaired from doing their government work.
Absolutely. Absolutely. For divestiture, this is where the filer sells an asset which was a conflict. And once again, this can be ordered or mandated by the agency as a condition of employment. As a supervisor, this is probably your favored resolution because it means now you can assign your employee to work on virtually any matter. For the employee, this may be a little bit more of a problem. So this is something that you want to work out with all the parties, including your agency ethics official. Reassignment, once again, that would be a management resolution based on you, the supervisor, You might want to get HR involved if you think that your employee is so conflicted that he can't do any work for you. Maybe he could be reassigned someplace else in the agency. Once again, that's sort of a management resolution.
Yeah, I see this sometimes when an employee has a conflict with, say, a spouse's employer. Imagine you had a contracting specialist who was assigned to a contract that involved the spouse's employer.
Mm-hmm.
It might be possible to reassign that person to a contract with a different vendor with whom he or she didn't have a conflict. That's the place where I see that most frequently.
Absolutely. Absolutely. Okay, trust, please just ignore that part. If some filer comes to you and says, I want to make a qualified trust, just send them directly to the agency ethics official. The ethics official will come to us at OGE, and we will say no, and then it'll just go back down the... I'm oversimplifying, of course.
We first give them the voluminous reporting requirements and paperwork activities that have to be undertaken for a qualified trust, and then they realize the expense that's going to be involved and decide upon another remedy. It's how I've experienced it.
Okay, the next one is waivers. Once again, these are kind of a big deal because what the agency is doing is waiving a criminal statute in writing in consultation with OGE. And it essentially means that even though the filer has a particular holding that is a conflict, the agency with OGE has determined that it's okay. Now, you can imagine that the Department of Justice keeps an eye on these things because we're waiving a criminal statute. It might be a good management resolution because that way your employer stays happy because they can hold the asset and you're happy because you can assign them to those duties. But it's a big deal. As I said, OGE has to get involved. And if that happens, of course, that's going to be done by your agency ethics official. There are also gift remedies under the standards of conduct. For example, a filer could return a gift or pay market value, et cetera, et cetera. And I just wanted to touch on the concept of ethics agreements as well. You may want to have a document in writing specifying the actions that both the filer and management are going to take to ensure the continuation of any remedy. In any event, the remedy selected will probably have an impact on you as the supervisor's ability to assign specific tasks to the employee. You may want to make sure that you're part of the process, if only to know what these specific expectations are.
I think that's exactly right. And that's sort of been a theme today, that this is a team effort between the expertise of the ethics office, the special information that the supervisor has, and the employee who we want to keep out of trouble.
Absolutely. Oh, okay. To sum up, from the perspective of intermediate or supervisory review, we covered the process, the form, and potential remedies. I hope you found this course to be of some value in your role as a supervisor and can use it, by it I mean financial disclosure, to better manage your employees and help keep them out of trouble. And once again, please remember to make maximum use of your agency ethics official. That's their job.
Excellent. Well, thank you very much, Mark. This has been extraordinarily enlightening and I hope helpful to our intermediate reviewers. Michelle, we'd like to open it up for any questions that we might have on the phone. And again, those folks on the Hangout, you can use the Hangout app to type in any questions you might have.
Thank you. If you would like to ask a question on the phone line, please press *1 on your touch-tone phone, unmute your phone, and record your name clearly when prompted. To withdraw your question, please press *2. Thank you. One moment for the first question.
Excellent. Thanks, Michelle.
I don't have any questions on the phone line at this time.
Excellent. Well, thank you, Michelle. And thank you, Mark, very much for joining us. We really appreciate this presentation. And again, this recording will be available on the Institute for Ethics in Government YouTube channel, so you can share that link with any intermediate reviewers you have at your agency for this filing season or any filing seasons in the future. And again, we'd like to remind you that next week we will be in St. Louis for the Regional Symposium. For any of you who will be there, we look forward to seeing you. Registration is open for the April 15th Regional Symposium in Research Triangle Park in North Carolina. Next week we have Patrick Kelly from the Federal Bureau of Investigations on the Advanced Practitioner Series. So for the Institute for Ethics in Government, OGE, I'm Patrick Shepard, and we'll see you next time.